Hello, everyone. My name is Eche Senyo Ahame, and I want you to uh, get connected to my channel or my page that is Legal Life Skills Educators, and then we can go on a journey of some legal knowledge, sharing legal knowledge, and then understanding certain legal issues. So, when the issue of the submission of no case came up in the ambulance trial, a lot of you have been asking me about the remits of submission of no case. So I'm just using this quick video to show you what it means when we say submission of no case. So in criminal trials, the law allows that the prosecution must prove its case beyond reasonable doubt, and that is a standard for the prosecution. So, in proving your case beyond reasonable doubt by the prosecution, it's important for the prosecution to adduce evidence. First of all, the evidence must be very relevant evidence that ensures that the case of the prosecution is well made out. Now, all these evidence that you adduce them to prove what we call the elements of the offense. The elements of the offense are the ingredients that makes up the offense. So you must prove all the elements. In fact, when one element is unproven or not proven, okay, then the prosecution have not made out a case yet against the accused person. And that is the reason why when you are a prosecutor, you must make sure that you know all the elements of the offenses that you are prosecuting. If you are prosecuting, for example, an offense, for example, murder, you're supposed to have the elements at your fingertips. One of the elements is that there must be somebody who is dead. There must be a dead person. That dead person must die out of harm. The harm must be unlawful, and that it is the accused person who actually administered the unlawful harm that caused the death of the accused person. So, with these elements proven, the prosecution can make a headway in trying a in trying a murder offense. So, when it comes to submission of no case, it is a situation or the stage in criminal trial where the court or the judge reviews the evidence that has been adduced by the prosecution and comes to a determination whether or not the accused person has a case to answer. So essentially, we are saying that when we look at the entire evidence that has been adduced by the prosecution, it does not really calls for the accused person to open his or her defense because there's no case for the accused person to answer. That is basically what it says. And then, secondly, if the judge or the court goes through the evidence and says that indeed the evidence connects the accused person to the offense or the elements of the offense have been proven, then the accused person is called upon to open his or her defense. So, at that point, it is the determination by the court. That is what the law says. However, in practice, what happens is that the accused person's lawyer will do a submission of no case and then indicate in certainty that indeed the prosecution has not made a case against the accused person. Remember that because the lawyer has submitted in a written form or in an address form, the prosecution is also allowed to respond. So the prosecution will respond either also in a written form or in an address, and then also state that when you consider the elements as a whole, indeed a case has been made against the accused. So the moment it is pronounced that by the court that the there's no case against the prosecution has not made any case against the accused person, The legal effect is that the accused person is acquitted and discharged, and he goes away as a free person. However, if a case is made against the accused person, then the accused person is called upon to open his or her defense. Now, in other situations, the accused person can appeal. The accused person will appeal when the submission of no case is rejected by the trial court. And the appellate court is also bound to review the entire evidence as adduced by the prosecution and come to a determination that indeed a case has been made against the accused or a case has not been made against the accused. Now, if the accused person also feels that if the prosecution also feels that the ruling does not go in its favor, it can also appeal and say that indeed, when we look at the evidence, a case was made against the accused, and therefore the accused should be called upon to open his or her defense. So basically, this is a remit of submission of no case. I believe that you like this video. What I want you to do is that like it, like it, and like it. Then you also share. It's very, very important for people to learn. I mean, law is law, legal knowledge is basic. Everybody should be able to have some legal knowledge, and then keep yourself going. So share it so that it will go viral. And then subscribe, hit the notification button so that you can also get notification when we post videos of this nature. Thank you very much, and I believe that I'm going to see you in my next video because you have actually subscribed and you have also pressed the notification button. Thank you very much, and I'll see you in my next video.